Welcome back. You're watching Big Deal and we are discussing the competition law changes and what it means for M&A as well as competition in the country. So Amit, we were discussing some of the very important points, and one thing that stands out for me is the hub and spoke model as well, and identifying cartels over there. So what is CCI's intent in the change in the definition which has come about in terms of the bill passage compared to what was there in the amendment, and how does it impact the hub and spoke cartelization in the country?
So the original definition, which was in the proposed bill, said that you will not only cover agreements between entities that are in the same production of the same products or services, but you will also cover a hub that might be formed to which they are the spokes. In other words, another entity that isn't engaged in that particular business, but forms a hub for the agreement between entities that are engaged in the same business.
Should be association for that
like an
sector.
Association, like an association of manufacturers of a particular product or suppliers of a particular service was the intent.
Yes.
But the worry was, in a nutshell, that this might also cover, for example, intermediaries in online businesses.
Yes.
And that's what the standing committee raised as a concern. So they said it should actually cover those who intend to further the agreement between entities in the same business.
Right.
That was their intent. But the actual language that I find has come out in the eventual statute has perhaps missed the point, because it now covers both entities that participate or intend to participate in furtherance of the agreement. They are presumed to be party to the agreement, even if not engaged in the same product or service production or supply. And that may, as a result, be overbroad in my view and misses the point that the standing committee raised in their remarks to avoid covering intermediaries online. I believe that it's now a little overbroad. It raises a concern.
All right, so that's an important one. And Pallavi, on the settlement aspect, a lot of corporates and legal fraternity had welcomed the settlement aspect, but the compensation bit and no appeal after that. These are some of those nitty-gritties which could be a concern. Can you explain that, please?
Yeah, so settlement and compensation is a very, very welcome change. Two things. It applies only to abuse of dominance and vertical agreements. It does not apply to cartels at all. That is covered by the leniency regime. Secondly, it will cut short all the litigation that continues for years and years. And thirdly, since there are going to be no appeals, these are negotiated sort of commitments or negotiated settlements, I think there will be no appeal. So the entire process is crunched. Now, what is a settlement? A settlement happens when the commission starts an investigation, the investigation is complete, and the Director General's report is available. From that time onwards, till the final order is passed by the Competition Commission, parties can approach the CCI and say, look, we realize what we've done and we want to settle the whole matter with you. There will be some conversations and discussions on what would be the amount of settlement, and going further, what steps will they take and how will they go about it. So it happens when you negotiate a settlement after the report is available.
All right. Yes. No. So on compensation, what is your view, Pallavi?
That is so compensation. Now, there is a little bit of detail that's not available. Whether when we apply for either a commitment, which is before the DG's report comes in, or for a settlement when after the DG reports come in, whether we have to admit or the companies will need to admit guilt or not is another question. So what happens, particularly in commitments, it's important whether they can agree to commitments even without admitting any guilt or any contravention of the act.
Right.
Insofar as the settlements are also concerned, the tendency generally is to say, okay, there is already a report against you, so let's just proceed from then on.
Right. So Pallavi, I got the point. Amit, in your view, Do you think this will lead to more settlements, or companies would like to fight it out, given that there is a compensation element and there could be admission of guilt or liability as it is showcased right now?
Both of those factors, Nisha, will be a deterrent towards settlement.
Yes.
Could have been avoided. The compensation part was not in the original bill. It was actually recommended by the standing committee, and it comes in pursuant to their recommendation, and it may be a deterrent. But apart from that, I think it's a wonderfully positive move if it helps to actually reduce the litigation and resolve enforcement proceedings much more quickly, and bring certainty to the process. It's not in India alone that this has been introduced. It's been in foreign jurisdictions for a long time, and I think it is one of the most important amendments in the present bill. It's almost revolutionary as far as India is concerned. I think it reflects that the CCI is quite happy with the way the leniency provisions have proceeded so far. They want to extend that now to other facets, abuse of dominance and vertical agreements. And I think it's a wonderful development. Of course, there are these
development, yes, but Amit, there are deterrents, and we'll have to see how CCI really articulates it. So it is not the solution as of now. But one quick word, Pallavi, as we wrap the show, is on the DG powers, and it also includes the agents and employees of the companies, including the legal experts, and that is quite a bit of concern for your fraternity, which are part of the corporate world. A quick word on that.
I think where the legal fraternity is involved is the in-house general counsel. I think the reasoning seems to be that they are employees of a company. They're not practicing lawyers in that sense, and therefore they can be questioned.
All right. So
because in India, in-house counsel do not have legal privilege, which practicing lawyers or external lawyers have that legal privilege.
Yes.
By virtue of the provisions of the Indian Evidence
this is that legal privilege of Evidence Act that some of the general counsels now seek after this particular amendment. Amit Sibal as well as Pallavi, we've completely run out of time, but we have actually identified several of those technicalities which CCI will need to articulate clearly in its fine print to these amendments, and then that competition law will evolve. So thank you so much, both the legal experts, Pallavi as well as Amit, for joining in. With that, it's the wrap on this edition of Big Deal. Thanks so much.